There are only 3 ways your partner gets legal power in Colorado: marriage, paperwork, and a judge. And if you're not legally married and you don't have the paperwork, you're left with the judge. That's not romance. That's how the legal system is built. Today, I'm going to get technical and then make it plain English. I'm going to break down the actual legal machinery that affects unmarried couples in the state of Colorado. Common law marriage, what it really is, how it's proven, and why it's risky as a protection plan. Then we'll walk through the 3 legal channels that control everything: decision making while you're alive, transfer of assets when you die, and who has authority when there's conflict. This is education, not personal legal advice. Your own facts actually matter, but the framework is pretty consistent from client to client. Colorado law is not designed to recognize relationships. It's designed to recognize legal status and legal authority. Marriage is a legal status. It comes with an automatic bundle of rights. If you're not married, you don't automatically get that bundle. Not for healthcare, not for finances, not for inheritance, not for controlling the process after a death. So the problem is not the law is mean, the problem is the law is default based. And defaults don't really fit a lot of your day-to-day normal situations. Here's the mistake I see constantly in my legal practice. Unmarried couples confuse 3 different ideas: committed relationships, common law marriage, and protected partner. Those are not the same thing. Those are not the same thing for everybody. And if you want a protected partner in Colorado, you have to build legal authority on purpose. So let's go into depths of how that would actually look like. Let's start with the myth that causes the most harm: common law marriage. Colorado still recognizes common law marriage, but common law marriage is not time served. There is no, we bought a house, so we're basically married. The modern legal framework was refined by the Colorado Supreme Court. The core concept is this: a common law marriage may be established by mutual consent or agreement to enter into the social institution of marriage, followed by conduct that manifests that agreement. That phrase matters. Legal and social institution of marriage. Not we're just committed, we share a life, or we put ourselves out as a married couple, but actual agreement in the legal sense. And then the conduct that shows it. So what does the court look at? A court looks at the totality of their circumstances, and they have to be proven in a courtroom, not just one single factor. I get asked this a lot. It really depends on the totality of the circumstances when the court reviews everything. So here are some of the examples that the court may look at. Have you each called each other husband and wife publicly? Have you referred to each other as spouse? Have you filed taxes together? Have you combined finances in a way that's consistent for a married couple? There is no single magic document. There is no automatic certificate. And yes, a couple can be common law married in Colorado, but it doesn't mean it's a safe planning strategy, because it's not proactive and it is actually getting litigated, and it can be very expensive to prove. Now, if you're legally common law married, then you can actually get a divorce to end it. You may have marital property rights and obligations. So relying on common law marriage creates 2 kinds of risks. You might not be recognized when you need it, or you might be recognized in ways that you don't anticipate. That's why, as an estate planning attorney, I don't treat it as a plan. I treat it as a legal status question that would be left up to the courts if one of the common law spouses dies first and leaves no plan. All of this will be litigated, which can be very expensive, very time consuming, and very stressful. So it's huge. You also cannot designate your common law spouse as a direct beneficiary on your 401k and have them enjoy the same lifetime stretch of the taxes as a legal spouse would. But those 401k designations actually overwrite your will. So a beneficiary form on your 401k, your beneficiary form on your life insurance, the transfer and death registration. So when you say I wrote a will, but you didn't coordinate all of your beneficiaries with the will, it doesn't automatically transfer everything, even if the will says everything. The beneficiary designations will actually override your will, but your common law spouse doesn't get the same protections as a beneficiary as an actual spouse would. So decision making when you're alive. Let's talk a little bit about that. Again, even when people are legally married, the law does not presume that your spouse would have your best interest at heart, so it's not an automatic default for your spouse, even if you're legally married, to have access to all of your financial or medical information in case of incapacity. So even for married spouses, it's very important to have a set of powers of attorney, and you need 2. One will be, we call it a general durable power of attorney, and that would be used in case of incapacity for any legal and financial decision making. And then there's also the healthcare power of attorney that designates an agent to make all of your medical decisions if something were to happen to you. And another big issue with the lack of planning is that if something were to happen to you, your common law spouse would have to go through the probate court. Probate court is the process that happens when somebody dies, what we call intestate, meaning they haven't left a plan. But the big surprise to a lot of people is also that Even if you have a will, a basic will that says everything goes to these people, that still does not avoid probate. And your common law spouse may need to be proving to the probate court that they are actually common law married to you. So they have to put all of the other potential beneficiaries on notice, fight them in court, everybody gets attorneys. It turns pretty ugly pretty quickly. We actually had a case like that where a common law wife was trying to fight the kids of her deceased common law husband because she was the primary caretaker. She was living with him. They shared all of the expenses. But when he died, she had no legal authority and she had to fight his kids in court to prove that they were common law married. And that took years. So what does the strong technical protection plan look like for an unmarried couple in Colorado? First, you have to build that authority for incapacity. Medical power of attorney, general durable power of attorney, HIPAA release. Second, you have to build a transfer plan. Know what assets will hit probate, know which assets go outside of probate, and how those beneficiary designations actually work. And then coordinate that intentionally. You may want to look into creating a trust and having specific designations for your common law spouse, because a trust does not have to go to probate, so whatever you say in there becomes the law. Third, you need to decide whether you actually need to fund the trust with some assets if you decide to go with the trust. You need to, again, review all of your beneficiary designations, and you need to make sure that those coordinate with your trust. Fourth, you need to talk to all of your professionals, your attorney, your CPA, your financial advisor, to see exactly how to coordinate the beneficiary designations with the non-spouse beneficiary through will, trust, or any other beneficiary designations. And finally, you have to maintain that plan, meaning that things will change. You may add another account, you may buy a new home, you may actually legalize your relationship and enter into an actual marriage. All of that needs to be reflected in your plan. It's not just paperwork, it's a strategy that you have to revisit and update as you go through life. So now that I've educated you on the different aspects of common law marriage in Colorado and how failing to plan can really hurt you and your partner, I invite you to schedule a consultation and make sure we talk through all of this. And if you found this video useful, please leave us a like and follow us to get more of our videos in the future.